Thank you for joining us tonight to talk about the future of marijuana in Oregon. My name is Noelle Crombie. I'm a staff writer at the Oregonian, where my beat happens to be marijuana. We're going to cover a lot of ground tonight, and so here's sort of the plan. I'm going to ask these guys some questions until about 7, and then I'm going to open it up for questions from you. So let me introduce our guests. These folks represent a sort of brain trust of marijuana policy in Oregon. So if you've got questions, these are people that you're going to want to have answered them. First, we've got Anthony Johnson. He's an attorney and the director of New Approach Oregon, which is the political action committee responsible for the ballot measure that legalized and regulated marijuana in Oregon. Dave Koblak is seated next to Anthony. He is a business attorney with Emerge Law Group in Portland. He was the primary drafter of Measure 91. Rob Vivette is legal counsel for the Association of Oregon Counties and former district attorney in Lincoln County. Rob sat on the Rules Advisory Committee for the Medical Marijuana Dispensary Program, as did Anthony. And Steve Martin, seated next to me, is the executive director of the Oregon Liquor Control Commission, the agency charged with implementing rules and regulations for the state's recreational marijuana industry. So let's begin with a basic overview of the new law. Dave, I'm hoping that you can sort of tell us, what does the new law do?
Hello, everyone. What does the new law do? Okay. Well, I guess I'll start with the themes of it. I mean, obviously, it legalizes and regulates and controls cannabis, marijuana, industrial hemp. When we first started drafting this, which was very soon after Oregon's 2012 measure failed, we sort of went back to the drawing board and figured out, thought about what we might want to do. Washington had just passed, Colorado had just passed, Oregon didn't pass, so we put all that together, and we're trying to put together something that we thought had a decent shot at 2014. At that time, we weren't even sure we were going to go in 2014, but we started the process. Our first decision was to go with the OLCC. We figured that they were the agency that made the most sense to regulate a recreational market. So once we made that decision, we went to the Liquor Act, and we basically just read through the Liquor Act and figured out whether any of that made any sense, and a lot of it we thought did. So probably half of our statute is copied directly from the Liquor Act. Not all of it made sense, and taxes and other things that we'll probably talk about later, we deviated from, but there was a bunch of stuff that we just copied right over. Another theme that we sort of early on, and we were thinking of these themes before we really started to put pencil to paper. Another theme was we wanted to minimize the illegal market to the greatest extent possible. We sort of foresaw what the problems that Washington is having now. It was pretty evident to us when we read the measure that those problems were going to occur. It seemed to us that we were going to try to come at this from more of a capitalistic free enterprise viewpoint, not to favor big marijuana, but to incentivize businesses to participate in the regulated system, and with a proper taxation and pricing structure to incentivize consumers who are perhaps now buying from someone illegally to go to a store, to go to a licensed store. So you have to incentivize businesses to participate. You want to incentivize consumers to purchase from a legalized market. So those were the sort of main themes. And then we worked on our taxation structure quite a bit, and we can get into that. But I think that's, and we ended up with kind of a long measure. That was a process in and of itself. We initially went to the legislature. Oh, and another early decision was we decided to try to put this through the legislature. That was probably a Hail Mary kind of dream we had, but we thought that if we could lobby the 2013 legislature to say to them, hey, this is likely to happen, why don't you all participate and play a role in this? And we had some success. We got some great feedback from that process, but ultimately they decided to not pass legislation, which then led to us filing a ballot measure. So I'd say from the spring of 2013 through when we filed in the summer of 2014 or so, or August, I mean, we probably, well, actually the fall of 2014, we probably went through more than 50 drafts of the measure. I mean, it just kept growing, and we kept thinking, and it actually shrank back at some point. But there was this drafting committee. We had a lot of folks working on it. We tried to get as much feedback as possible. But I think those themes sort of survived through all that. And the themes, again, being the OLCC, minimize the illegal market, and regulate in a manner substantially similar to here in Wyoming.
So you set out a framework that the OLCC will be filling in your rules. You didn't get into the specifics.
Yeah, Steve can comment, but I think we tried to give the OLCC a fairly broad rulemaking authority.
And I do have questions for Steve about that, but I wanted to ask you, the federal government has taken a largely hands-off role in Colorado and Washington. The Attorney General has been clear about their 8 law enforcement priorities around marijuana. They include keeping it from minors, reducing diversion, smuggling out of state. How did you take those priorities into account when drafting the law?
So Noel's talking about the Cole memo. Do any of you know what the Cole memo is, or some of you? So briefly, it is a memorandum from the U.S. Department of Justice from a particular guy named Mr. Cole, who it's a memo to federal attorneys saying that here's the federal government's 8 priorities with respect to marijuana, and that's what we the federal government, really care about. And if the state, and keep in mind this was drafted in August of 2013, so this is after Colorado and Washington had passed, and so they were in a political situation where they had to react in some way. So they said, as long as if a state has a regulated system that is robust enough that these 8 priorities are being satisfied, then we're okay. I mean, from an allocation of resources standpoint, we don't think it's worth it necessarily for federal attorneys to spend time and money on that if a regulated system is going to address these priorities. And so that was kind of a green light to activists in the industry that, hey, if we can come up with a decent ballot measure and decent rules, that we're going to be okay from federal interference. That actually occurred, like I said, in August of 2013. We were nearly done with the measure so that caused us to sort of re-examine everything. And I think we tinkered a little bit, but by and large, a lot of those things are very common sense things, in which I think every Oregonian should probably be in favor of. So we didn't really have to go back to the drawing board very much on that. There were a couple things we might tinker with, but that's about it.
Steve, how will those federal priorities fit into the work that you're about to begin?
I appreciate the opportunity to be here. I just want to say Rob Patridge, our chair, would have liked to have been here. He was unable to make it, but he's the chair of this commission. And I think, it's really clear that the Cole memo is our outline. They're sort of the points of light for understanding and making sure that public safety is protected in Oregon, that we comply and don't reach the scrutiny level of federal intervention with the way we implement our law. So, Measure 91, otherwise our role is obviously to provide the licensing of that for the growers, the processors, those that would wholesale, retail marijuana, and then last, I guess, retail. So our responsibility really is to create that legal system in the framework within the Cole memo. So we've got to be careful that we contain the product that's in our legal system and keep that product within the legal system. You don't have leakages outside that system. And then I'd say, this is maybe less the Cole memo, but I'd say there certainly is an emphasis in that and within the ballot measure to make sure that minors don't have access to that system.
So before we move into questions about the regulated production and sale of marijuana, I wanted to stick with a couple questions about home cultivation and possession. I get a lot of questions from readers about, particularly on home cultivation. Anthony, I'm wondering if you can sort of give an overview of what the law allows in terms of cultivation at home, and also will the state have any regulatory authority over people who are growing at home?
Yeah, as Dave touched upon, a big theme of Measure 91 was to regulate marijuana, substantially similar to how the state regulates beer and wine. Oregonians can craft their own beer, they can produce their own wine within limits. There are actually limits to how much you can produce, and you can use it for home consumption, you can share it, but you're not allowed to sell it. So we wanted to come up with a framework very similar for cannabis. And so Oregonians, starting officially on July 1st, hopefully we can see that sooner, outside of Multnomah County and potentially Clackamas County, but hopefully sooner, can cultivate 4 plants per household, possess 8 ounces of dried usable marijuana, 16 ounces of solids, 72 ounces of liquids, and 1 ounce of concentrate at home. Away from home, you're allowed 1 ounce in public, out of public view. And just as the really state stays out of the regulation of home cultivation or home production of beer and wine, so long as people are within their limits and there aren't any complaints or any, there's no reason to suspect somebody is violating the law by selling home brew or home. I expect that the state will allow the home cultivation limits, which are really reasonable and in line with similar to beer and wine, that those home cultivation limits can remain.
Rob, do you see cities and counties, local governments responding or having any concerns about home cultivation?
No, other than potentially the nuisance aspect. So I can see cities and counties getting complaints from one neighbor against another because they're getting smelled out of their house. But maybe I should give, if it's okay, I'll give a disclaimer for the 3 lawyers here, and then I'll do a couple of things different than Anthony has said, but I think you'll agree with them. One is, you can't rely on any of the advice we give. We're not your lawyer. Check with your own lawyers. I've done that for all 3 of us. Now, I've gotten a lot of questions as well. Sorry, I had to. Got a lot of questions as well on the home stuff, which is completely separate and apart from what Steve's going to be regulating in the beginning of 2016. So we've got 2 big things that Measure 91 did. It's got the regulation, taxation, legalization, and then we've got this, what I call personal allowance stuff, which Anthony's done a great job summarizing. But I would put a couple cautions for people that are going to jump out and do this based on what Anthony summarized, because Measure 91 made it clear that it didn't impact landlord-tenant rights. So I can see some rubs potentially happening where tenants think they can do all this stuff, but their landlord says, oh no. And so Dave's written and crafted a measure, finally crafted a measure that would exempt them from criminal prosecution, but then they're evicted. So that won't help, right? So people need to be aware of that. There's also a potential limitation, depending on how you interpret Measure 91, and I interpret it in a particular way, where Dave crafted it to exempt people from manufacturing and delivery of marijuana, the general statute, but not the enhanced statute for within 1,000 feet of the school. So like my home in Newport is within 1,000 feet of 3 schools. So I'll be able to possess everything that Anthony mentioned, but I don't think I can grow my 4 plants, and I don't think I can share with my friends as long as I'm within 1,000 feet of the school. Now, different people may interpret that differently, but that's how I read 91, so I wouldn't want people to, that are within those 1,000-foot circles to do things that potentially they are allowed to do. So I just throw that couple quick caveats as we dig deeper into Measure 91 details. And I don't know if either of these guys disagree with what I've said, but
No, I mean that's what we did. And some of this just at some levels was politics for a while, right? So when we were going through the legislature in 2013, we were strongly advised to not mess around with the 1,000 foot within school rules. I mean, just as a pure political matter, you're going to get pushback on that, and so calculations were made, and does it make complete logical sense to me that somebody can have the home grow 1,025 feet away from the school, but not 975 feet away from the school? No, but that was a decision that was made, and maybe there's some future, something to think about there. Well, I should say this too. I mean, the points you raised, Rob, are good because I think the more talks we can have, the more people can be educated and know what they can do can only benefit everybody.
And keep folks out of trouble.
Yeah, well, Rob makes a good point, and that can definitely be interpreted that way. I would say the overall intent of Measure 91 was to keep retail establishment on large groves away from schools, and to clarify that, I would like to potentially see a legislative fix to allow people to have floor plans out of public view and to share the ounce that's allowed in Measure 91 without the fear of that interpretation.
Let's switch gears to the regulated production and sale of marijuana. Steve, your agency has a lot of authority over what the new industry will look like. Can you talk about the discussions your agency has had so far about the law and how you plan to proceed?
Sure. I've been at that agency for a year, and I'll tell you, right after we got out of that short session, last time we started turning and taking a look at what's this marijuana ballot measure about, how can we coordinate it, state government, and we did that process, and there's some official roles that you have, and the ballot measure was a part of helping to come up with the price tag for it. We further coordinated in September, thinking about what it would take us to implement this measure and the timing. But because there was an election on, we're an agency that's funded by a wicker. It's not our primary activity, so we left it at that. We have the ideas moving forward now. Of course, we're going to be funded. We got a request into the emergency board in December to pull a staff on. With that staff, we'll begin to put together the plan for public hearings, public consideration, and stakeholder meetings around the state, starting in January. For those of you that have already gone on it, one of the things that we did right after the measure passed was we had prepared a document of frequently asked questions about what our role would be, and my staff would whip me if I didn't tell you about marijuana.oregon.gov. That is a website to get information about how we're developing this system. On there you can sign up for emails to notify you of changes as we move forward. So we're putting a staff on, we're going to get funding for that. The plan looks like we'll get around the state in late January, early February to hear from Oregonians about what you think and feel about the implementation and intricacies of balancing out these issues that we're discussing here in our role. But our role is simply to work under the strictures of Measure 91 as it exists to begin to develop the rules to implement it. So we need to get in place rules for the grow, rules for the processors, rules for wholesalers, the application processes for that license, and then of course retail. So it's going to take a while to do that. Right now, in terms of our administrative processes, one of the things that we have to do is also tax the product. We're looking, both Colorado and Washington have used a seed-to-sale system to track marijuana through each stage of its process. We want to investigate whether that's something that's right for Oregon's system of implementation. We think it has some advantages, so we're going to be looking at those systems, pricing and learning about them so we can take to the legislature a proposal to potentially use that kind of system in Oregon's system of licensure and regulation. The legislature is going to be in place as we move into this rulemaking and development period. So we're going to watch very closely and help and assist the process there. We'll be working with the stakeholders and the legislature to see how the other things that they do and the changes that they would consider play into our regulatory structure. So I'm hoping that what happens is we can have a more orderly full development of rules and licensing post-July when the session adjourns. And then we would move forward. We have to accept license applications in January of 16. And then from that point, we would begin, I think, in terms of thinking about stages. You got to license your grow and get that on the ground in front of the time so you don't want to run into the Washington supply problem. So we'd look at staging that, but it would be sometime, after that January of 16 when we'd accept applications and then get the growth started and then move from there towards retail operations.
So when do you think Oregonians could expect to see their first retail store open?
Good question. We'll be working on the budget. Part of that is a function of the funding for the measure. The legislature puts together the timing and the complexity of the system people want us to put in place. It would be, so I can't give you a definitive date, but I'm certain, given the timeline here, which is fairly aggressive for us to get to, is that it would be well after that July of 16 time frame when we're out there. I think that would be really, really early if we were doing retail. We're going to work with the governor, the legislature, public safety, and the advocates of the measure to try to get that set in place right. But we haven't done all that work in planning yet. I'm sure you will hear about a date in the coming months.
Let's shift gears to taxes. So many Oregon communities scramble to approve local taxes on marijuana sales before the election. Dave, what does Measure 91 say about local taxation of retail marijuana sales? And I know there may be some differences of opinion, so I'd like Rob to weigh in after you're done.
You're getting right to the controversial stuff now, right? Okay, so Measure 91 says, there's two particular provisions. One says the state shall have the exclusive right to tax, impose fees, a bunch of synonyms that mean taxes, fees, on marijuana. And then there's another section that says that any local ordinance or charter that's inconsistent with the act is superseded, repealed, gone. So those two provisions were copied. These are two of the provisions we copied directly from the Liquor Act. That's the way the Liquor Act reads. Local jurisdictions cannot run around imposing taxes on alcohol, and so we just thought it made sense. Not just because it was in the Liquor Act, though. I mean, we consulted with tax experts here, and the taxation part of this is really tricky. It plays in completely to our goal of minimizing the illegal market, because obviously your tax structure is going to affect your price, and your ultimate consumer price is going to affect how a consumer may decide to go stay with what they're doing or go to a store, which of course affects business. So it all plays into, do you want to minimize the illegal market to such a degree that you're bringing everybody into the system, or are we going to have a situation where only a small sliver of the actual economy is in a regulated portion, and your illegal market dominates? I think it's safe to say in Washington now that it's quite lopsided. The legal market in Washington represents a small minority of the actual market, and at some point you'd have to ask yourself, what's the point of that all? So we put those in there because we thought that the state had to come up with what I term as a cohesive tax policy. We set the taxes relatively low relative to Washington and Colorado for this sort of, incentivizing, minimizing the illegal market. And we learned a couple things from talking to these tax folks. These are tax policy folks who think from like an IRS perspective about how taxes affect people's behavior. If you want to get somebody to do something, how does your tax policy get them to do it? And what's an efficient way to tax? This is all very kind of complicated stuff, which I didn't completely fully appreciate, but there was lots of decent articles out there on it, and it's actually quite entertaining to read. But here are our lessons. Tax by weight, don't tax by price. Tax as early as possible in the distribution channel, which means the producer and not the retailer. Remain flexible. Watch what the illegal market does. The illegal market will respond to our prices. And so watch what they do and remain flexible. So we threw in a provision that says that the OLCC has to, from time to time, report back to the legislature and make recommendations about whether our taxation structure should be tinkered with, because we're not really doing a good job against the illegal market. And then, of course, the fifth part of that was give the state the sole and exclusive right to tax, because a state, you cannot have, again, a cohesive state policy, in my opinion, my personal opinion, if you have numerous local jurisdictions imposing taxes that are all over the map, with some imposing 0, some imposing 10, 20, 40%, whatever. So that was our thinking behind it. And so that's what it said.
Do you agree?
I agree basically with what he just said. Maybe I can amplify it a little bit or explain. So I would agree with Dave and Anthony to the extent that I think Oregon is uniquely situated compared to Colorado, Washington, even Alaska, D.C., to have the one-tier tax structure that Dave crafted actually potentially price retail marijuana at or below the organized black market. So I think we are uniquely situated to potentially drive out the organized black market if we do it right. If we create a tight regulated system and keep prices relatively low. That's the design. I agree that's the design. That's the goal. That's what we ought to be working toward. Now, having said that, I have to give you a second caveat. I don't represent cities. I can't speak for cities, and I'm not going to pretend to. But let's just talk about it, because we have a whole bunch of cities that impose additional taxes or purport to impose additional taxes at various levels and at various rates. And the logic I've heard being expressed publicly is that they have an argument that they should somehow be grandfathered because they predate the passage of Measure 91. Let me just say that I think what they're really saying is they want the legislature to grandfather them, right? I think that's what we've all agreed is really going on here politically. Now the question is, and I know the League of Oregon Cities has announced in your paper, I think you ran a story a couple of days ago about them. The League is basically going to go ask the legislature to remove that ban on local taxation. And I think what maybe a compromise position might be, is to not lift the ban on local taxation, but allow for limited small amount of taxation at a local level, especially for communities that are disparately impacted, which I'll explain more, but cap it so it doesn't fundamentally alter what Dave and Anthony are trying to accomplish by keeping retail prices low. So there may be some room to maneuver there. It won't make anybody happy on either side of that argument, but I think there is some room to maneuver based on the structure that we created. But that's probably fodder for further conversations.
Anthony, when it comes to local control under the new law, what kinds of restrictions or prohibitions can local governments impose on unregulated industry?
You have rules and regulations for time, place, and manner regarding the nuisance of marijuana. So like Rob talked about, there's various traffic issues, smell issues, the time that places can be open, the traffic going back and forth between certain neighborhoods. So basically the same rules and regulations they can have for other legitimate businesses, bars, breweries, wineries, and really to bring in line marijuana with other state licensed businesses as far as the rules and regulations that they can put in place.
Can they ban them?
The only ban allowed under Measure 91 is an actual election by the people. It's the same process for opting out of alcohol. I believe it was Monmouth was the last dry alcohol city, locality in Oregon. So if you want to have an election, put it on the ballot and opt out of licensed establishments, you can, but otherwise it cannot be opted out just by 4 members of the city council or county commission.
Rob, I know you have some thoughts on that issue. Can you talk about that?
Well, yeah, again, I can't speak for cities. They've come out and said that they're going to ask the legislature to alter that and allow city councils to opt out by a city council election. I don't know that my client AOC is going to ask for that. We may ask for something different than that. We may ask for something that deals with what I deem to be a potential 1-year gap in time, because Measure 91 directs his agencies to start taking applications for these licenses in January of 2016. The soonest that an election could occur at a local level would be November of 2016, would be effective January of 2017. So we got a year gap. Now, I recognize what Steve just said. It's probably unlikely they're going to be issuing licenses in January of 2016. They just have way too much work to do. But there may be some level of gap that we want the legislature to deal with one way or another. I'm not suggesting what that method will be, but we in some ways don't want to set people up for a bummer in the sense that they invest a lot of money, get a state license to open up manufacturer, wholesale, processor, or retailer, just to find out they've been banned 3 or 4 months after they've invested $100,000, and now that doesn't make any sense to me. So maybe we could find a legislative tweak to that issue to take care of the problem without undoing what they've tried to accomplish.
What are the kinds of concerns that your client, Association of Oregon Counties, has about the new one?
Well, I guess I should start with this. Unlike the medical marijuana dispensary statute, which my client had lots of concerns with because there was not a lot of flesh on the bones, and it gave the OHA, Oregon Health Authority, very limited regulatory authority. Dave did a nice job giving this guy's shop broader authority. So many of the concerns we'd had about the testers not being licensed and regulated, and the wholesalers not being tested and licensed and regulated, and all of these various systemic parts of the medical marijuana dispensary system that are virtually unregulated are not going to exist here. And so we may need to tune up the medical marijuana dispensary program to match what Steve's regulations look like so we don't have bleed out across the lines. And I think we may achieve some level of consensus with that. So with that diminishes many of my clients' laundry list of concerns to just a handful of what I would consider tweaks, a number of which we've already talked about here.
So let's shift to the issue of medical marijuana, which you just mentioned. Anthony said repeatedly in the campaign that the new law would not change the medical marijuana program, but officials in Washington that I've interviewed said that their medical program, which is unregulated, is real competition for the retail market, that it draws heavy consumers, they're not paying taxes on the product. How do you see that issue playing out here? What is the future of medical marijuana in an era of recreational marijuana in Oregon?
Well, I think, if I could start,
For all of you to weigh in on
I think there's a couple of points to recognize. I've had people ask me and suggest to me that the medical marijuana program over time will cease to exist. I don't think that's going to be the case at all. A couple of reasons for that. One is that the medical marijuana program can serve those that are under 21. The medical marijuana program often focuses on cannabinoids that are not THC because they're medically beneficial. So we may have different products tested at different levels with different cannabinoids in the medical program. So I don't think it's ever going to go away. What makes sense to me, and what I think they've been trying to do in Washington, not successfully thus far, is to make the programs not identical, but mirror images of each other, because frankly we have the same group of folks that are interested in being manufacturers for both programs, being wholesalers for both programs, potentially being retailers for both programs, and it doesn't make any sense to me as a practical matter to have programs that are regulated so differently that it's confusing to those being regulated. It makes sense to have the same type of functional systems for both. So you can have a grower, for example, that's licensed by Steve's shop and the OHA to grow, and that product can feed both systems.
Anthony, do you have any thoughts on
medical? Yeah, definitely. Medical marijuana program is definitely here to stay. I think a lot of kind of the rhetoric about the problems with the medical marijuana program are really, I think, overblown in Oregon. In Oregon, there are just under 70,000 patients. In Colorado, there are more than 240,000 patients, and they're not that much, population-wise, they're not nearly over 3 times the size of us. In Washington and California, no one even knows how many medical marijuana patients there are in Washington and California, because you don't have to even get registered with the state. Here in Oregon, you have to have a qualifying condition, you have to have medical records, you have to pay the fee to the state, and there are the hoops to jump through. So I don't think we're going to see any bleed out or any disruption from the regulated market from the Measure 91 facilities, because there just aren't really that many patients compared to all the cannabis consumers you're going to have over the age of 21. So I think that Measure 91 should be fully implemented, and that we should wait and see before we do any drastic changes with medical marijuana. I don't think any are needed now. I think through the course of the campaign, you heard the Measure 91 campaign basically say that we're going to regulate marijuana like beer and wine, we're going to save law enforcement resources, and the medical marijuana program is going to remain intact. And I think that's the will of the voters, and I think that should remain in place.
I agree with that 100%. However, I also agree to some extent with what you said, Rob. I mean, if I'm a producer, if I'm a retailer, if I'm somebody in the business, I would think that it doesn't serve anybody any good if you're going to have a particular, and I'm just picking this out of the hat, but if you're going to have a warning label, or you're going to have something like that, it doesn't seem to me to make sense to have two different warning labels. I mean, from two different agencies. And so I think there are efficient ways to sort of sync things up, and that has nothing to do with dismantling a program or not. It just has to do with making life and business kind of simple and smart. So I think there are opportunities to sort of say, okay, this is a regulation, it makes sense in both arenas, and so let's not have one set of regulations here that is entirely different from this set of regulations here when we're kind of trying to get to the same thing.
Steve, have you given some thought to how medical is going to relate to the...
Well, my commission formally doesn't play in this arena. We're just going to implement Measure 91. But, it's without question, it's kind of obvious there's going to be a debate at every stage of the system about duplication of regulation or not. So we're preparing for that. We're not primary players in that, but we can implement, the outcome of it as the legislature and folks think about what actually makes sense forward. So there's a broader theme, I think, around this, and it goes to our principles of what kind of system we want the system to be legal and accessible. There's some larger issues that are tangent to 91 that are out there that are going to be with the legislature in terms of how they look at medical and how it integrates, how this home grow fits in with the system, and then how we treat future enforcement of illegal grows, along with our responsibilities are going to be to sanction the bad players inside our licensed system. And I think it's really a construct that we can't just be concerned solely about 91 and think that we're going to accomplish every objective we want unless we think of the full system. It doesn't mean that the answer for now isn't that they're separate, but it's something that should be taken into consideration as we move forward. And it's not really at my commission's level. We're going to implement 91. If there are law changes, we'll implement that integration.
I've got one more question for Rob, and then I'm going to open it up. Rob, I'm hoping you could talk a little bit about the labeling and issues around edibles, marijuana-infused edibles. You've had some experience with that on the medical dispensary rule-making process, and I wondered if you could talk a little bit about that. Do you see that? What are the lessons for OLCC as it looks at edibles, which will be a big issue for them in the coming year?
Sure. So one of the many deficiencies we saw in the medical marijuana dispensary bill is it didn't address that. It didn't pay much authority to deal with that. And we were learning lessons from Colorado, who's now trying to tighten up a little bit of control over the medicals. And so we did another bill that actually gave OHA the authority to regulate those. To Dave's credit, the way I read 91, his shop has authority to do that, so we won't need to make any tweaks to fix that. That's already embedded in 91, and he has regulatory authority to learn lessons from both our dispensary program as well as from Colorado and Washington, and not make those same mistakes, and we can just deal with it heads up.
So I'm going to open up the forum to the audience. I'm going to call on you, and I'll try and repeat your question. If you could just let me know who you want your question addressed. Go ahead, sir.
Hi. Thanks for doing this. I had a question. I'm not really sure who it would be directed at, but I'm sort of curious about the part about not being able to do this in public. And if that's something that will, I'm uneducated about all the intricacies, but it seems a little shady, continues to keep it sort of shady, and it's sort of hypocritical. As far as when you look at the only thing, since you said you follow that alcohol, what they do with alcohol, that's sponsorships and you go to these public events. So that part of it, I'm wondering, is that something that you had to think about, and is that something that we looked at once people get more comfortable with what's happening?
Yeah,
As far as, I'm sorry, one part about that was when you think about the legality and then businesses that could come out of this, the hampering of any potential by not being able to do it.
Everybody hear the question, or should I?
So the question is, and you're talking about public consumption, is that what your
Yeah,
question
being
is?
able to do this, so you go to the store and then you have to go home, or you have to, or you want to, say, in the future, somebody wants to open some type of a venue for, you look at beer and wine and pubs and things to go and do, and you can't do that.
Right, so Dave, why didn't you look at this issue of public consumption in the measure?
You want to take the heat on this one, Anthony?
I'll take the heat first. When we're trying to repeal a policy that is 80 years in the making, that has been perpetuated, I think I'd argue with reefer madness kind of propaganda, and you're really trying to make a sea change policy that when you think about the politics and winning the ballot box, you want to have, we deliberately had a very deliberative, really relative conservative approach to legalizing and regulating marijuana, and part of that was not openly calling for, public consumption. And I think that over time there are things that we can look at about private clubs or things like that keeps it, make sure we keep it away from children, because unlike beer and wine, you have like smoke to worry about that could impact people on a picnic or whatever. So you want to take into account people's sensibilities. It's similar to that with the smoke, it's like tobacco, and how tobacco and where you can smoke tobacco has changed over time. So I think with marijuana, as people become more comfortable, and that we see that really the sky's not going to fall, and that we mature over time on the issue, that we're going to see a whole change of really tweaks along the way to really accommodate what you're talking about.